Hello, everyone. Welcome to the SLW Institute and to our series on international intellectual property law. I'm delighted to welcome today Clare Collins of Murgitroyd. Clare has a background in physics with a PhD in nanomaterials from Cambridge University. Clare works a lot in software and software-related technologies, AI, blockchain, and electronics. So Clare today is going to be covering what's new in European IP law and what's in the pipeline. And I'd like to say thank you very much to Clare for presenting to us today. So Clare, over to you.
Thank you very much, Maureen, and hello everyone. Good morning or good afternoon, wherever you are. I'll just share my slides and we can begin. Okay, so hopefully you can see that. Okay, so I'm going to talk to you, as Maureen said, about Europe IP, particularly patents, and a year in review and what to expect going forwards. So I'm going to start with a bit of discussion about the EPO and its structure and some statistics from the last year. I'm going to go over prosecution at the EPO and how it relates or it's different to US prosecution. Then we're going to look at a couple of decisions which have been somewhat influential over the last year, one on plausibility, one on entitlement to priority. I'm going to talk very briefly about some reduction in fees which have been introduced, and then what's to come in the pipeline and some pending referrals to look out for in the coming year. So let's get started with the EPO structure and some statistics. So a bit of a refresher about what the European patent is. It is a regional office, and it is primarily concerned with the granting of patents. So there's the filing and formalities examination that takes place when an applicant files an application. There's a search stage, and it's important to note that the EPO will always do their own searches. They will take into account other searches which have been done at other patent office, for example, but they will always do their own searches, and they're quite independent in that manner. Then there's some substantive examination. You can, perhaps if you're unlucky, end up at oral proceedings in examination, which are examination oral proceedings. These are closed, so they're not open to the public, and it's just between you and the examiners, the applicant and the examiners. You might have your application refused, or the applicant can choose to withdraw the application during this stage. And then hopefully your patent grants, and then it is validated in whichever validation states you choose. I'm sure everyone here is now very familiar with the new validation state or effective validation state of the unitary patent and the jurisdiction of the unitary patent court, which has been around for a couple of years now. I know you've probably had your ears burned listening to many Europeans like me talking about the unitary patent. So we're not going to talk about that too much today. So post-grant, there is the European Patent Office will listen to appeals if your application is refused during the substantive examination stage. There is also a limited 9-month window once your patent has granted, which a third party can raise an opposition. So the EPO will also hold opposition proceedings or possible limitation revocation proceedings. And these, again, can be appealed at the European Patent Office. It's important to note that the European Patent Office does not get involved in things like entitlement proceedings. They're dealt with nationally, and it doesn't deal with infringement proceedings either. And there is only this limited version of revocation in the form of opposition. So we've got a note here about the enlarged Board of Appeal. The enlarged Board of Appeal is where a lot of the big decisions come from. They're called G decisions, and these address crucial questions of law related to the interpretation and application of the European Patent Convention. We also have T decisions, which are decisions from the technical boards of appeal. These deal with specific technical issues arising from specific patent applications and appeals. The G decisions are more widely applicable than the T decisions, and we will, as I mentioned, we'll look at some of the G decisions which have been influential in the past year. So let's move on to looking at some statistics and some trends in patenting for the year 2024. So Europe is still an attractive technology market. Total patent applications were very slightly down by a total of 188 fewer filings than in 2023, but general fairly steady filing of patent applications at the European Patent Office. Amongst European applicants, slightly fewer applications from Italy and Sweden. Interestingly, maybe more from non-EU states such as UK and Switzerland. The US is a very big contributor to European patent filings, accounting for about 24% of patent applications filed last year at the European Patent Office. Again, what is interesting to note is that this is actually down by 0.8% compared to 2023. The top technology fields for the year are largely being driven by AI and battery technologies, with increases in computer technology, electrical machinery, apparatus, energy, transport, all on the up, with a slight decrease in digital communication, medical technology, and pharma, actually. The top applicants, none of the top 5 are European. As you can see there, they're from Korea. This is the bright green, China in the kind of bluey green, and the US in black. So out of the top 5, 2 of those are US companies. So we'll dig a bit into each of those a little bit more. So looking at the trends in applications and grants. So this first graph on the top left-hand side here shows the number of patent applications, the total number of patent applications that have been filed from 2015 up to 2024, and shows a general increase. The graph on the right here actually shows the number of grants from 2015 to 2024. You can see the US has constantly been, US is this light blue line in the left-hand figure. And in fact, my next slide has is just focusing on the US. So a very steady increase over the last 10 years. But what is particularly interesting is this dip. And the dip is in the granted patent applications. So the recession, or the decrease, I should say, in patents being granted kind of began around 2020 after the pandemic, and kind of started to rise again in 2023 and again in 2024. So the examiners at the European Patent Office have been given a mandate to improve grant rates, and they've actually been much more active in communicating with us as European patent attorneys in the last few years. I've had, for example, one examiner requested to have a very informal chat with me. They didn't want to issue a summons to oral proceedings, which is much more formal. They wanted to just get a better idea of what was going on with the application in a more informal setting, and that's quite rare, but possibly increasing more. Examiners have also been making more suggestions. I've had, there are some examiners are naturally more picky than others and more strict about some things, but there has been a noticeable increase in examiners being willing to grant, basically, and discuss with us what they think would be allowable. Of course, sometimes what the examiner says is allowable is not always what the applicant wants, but this increase in communication between us and the examiners is largely responsible for this increase in number of grants. So I spoke very briefly earlier from that main slide about the US being a big contributor to filings at the European Patent Office. And if we look at so the red states are all the European together. If we look at them together, then Europe is the biggest filer. But if we look at individual countries, then it's the US. And I'm sure that you will recognize many of the companies in the United States, top 10 applicants in 2024 at the European Patent Office. So, as I said, some of the technology fields of the top 10 are largely being driven by AI and like EVs, for example, and this is largely reflected in the technology fields that the US patent applications have been filed in. What about SLW? Well, I guess you generally work in those same fields that I've just talked about, increases in computer technology, electrical machinery, transport. So, yeah, that's that. So what about the unitary patent and the uptake in the US? So the little world map I have here, the darker the country, the greater the participation and the uptake in the unitary patent. Again, Germany has been the biggest uptake, but the US comes second and has shown a great uptake in requests for unitary patents, with this pie chart showing that 15.6% of the unitary patent requests have come from the US. Again, this is the top 25 proprietors that have requested unitary patents, and 1, 2, 3, 4 of those companies are US companies. The uptake is quite big in Europe. but also in Korea. So this slide shows which fields the unitary patent has been taken up in. And don't forget that this is about granted patents. This isn't about filed patents. So there could be a bit of a delay in which technologies were interesting maybe 5 to 10 years ago. But medical technology has interestingly seen the greatest uptake of unitary patents. But there has been generally well accepted, and lots of people are filing for unitary patents, which is good to see. So that brings us to the end of the statistics and the pretty pictures. And so now I'll go on to talking about prosecution at the EPO. So just a bit of an initial refresher about the EPO approach to examination, because there are some differences, as I'm sure you're aware, between the US and Europe. So the examiner will examine in a sequence. And if you fail any of these hurdles, the process can stop. So the examiner doesn't have to give you a full report which details every single one of these patentability matters in one examination report. So they will first look at added matter. So you could just get an examination report if there is added matter that simply says there is added matter, and they will ask you to fix that before they go on to looking at any of the other patentability hurdles. So once they've looked at added matter, they will move on to sufficiency, then clarity, then novelty, and then inventive step. Another difference between US examination reports and European examination reports is that they don't have to express an opinion on each and every claim. They will sometimes give you an indication as to if there are some potentially allowable claims, or why, very briefly, they do not think any of your dependent claims are patentable. But this is usually very brief. I think the longest US office action I've had has been about 93 pages long. But you would really be, I don't know if the word is lucky or unlucky, to get an examination report from a European examiner, which is more than 10 pages long. They will usually be 4 or 5 and quite succinct in their objections. So another major difference between the US and European approach to examination is inventive step. So the inventive step is quite formulaically based on the problem solution approach in Europe. And the problem solution approach, you identify the closest prior art first. This will be one document. Then from that one document, you identify the features that are different or that technically distinguish from your closest prior art. And from those technically distinguishing features, you formulate an objective technical problem. And then the final step is to evaluate whether, when faced with the problem, the person skilled in the art would arrive at your claim and your invention or not. So a little refresher on added matter. Article 1232 states that the European patent application or European patent may not be amended in such a way that it contains subject matter which extends beyond the content of the application as filed. So it's not usually allowable to base an amended claim on an extraction of isolated features from a set of features originally disclosed only in combination. For example, If there is a particular feature which is only described in one specific embodiment, examiners can ask you to include all of the features of that specific embodiment in order not to violate Article 1232. Amended subject matter that amounts to a generalization of a particular embodiment disclosed in the original application, but is more specific than the original definition of the invention in general terms, is often called an intermediate generalization. So don't forget that the EPO will look at added matter first before they look at any of the other hurdles to patentability. So it's important to get this right and to overcome any added matter objections. Just because you have no novelty or inventive step objections doesn't mean that the examiner necessarily considers that it is novel and inventive. So how can you avoid these intermediate generalizations and added matter objections in Europe? It can be useful to include more than one embodiment, if possible, and include more generalized language that will cover all of your potential embodiments. When you're providing instructions to your European attorneys, it's helpful if you can provide basis for the amendments that you want to make, preferably verbatim basis if you're amending from the specification, although of course this isn't always appropriate. But it's very hard for an examiner to say that there's no basis when it's taken directly from the specification. Also, cherry picking features from different embodiments is unlikely to be allowed. So then we move on to sufficiency, and Article 83 specifies that the European patent application shall disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. The guidelines for sufficiency say that a detailed description of at least one way of carrying out the invention is necessary. Any feature that is essential for implementing the invention must be disclosed in sufficient detail for practical application. A single example may be sufficient, but broader claims usually require multiple examples, alternative embodiments, or variations. So the application should provide enough information for a person skilled in the art to perform the invention over the entire claimed range without undue burden. A clear description of function may be more appropriate than an over-detailed description of structure. So classically, sufficiency has not been particularly a problem in computer software. It's been classically more something that life sciences attorneys have to deal with. However, with growing AI applications, sufficiency has started to be more relevant. And in fact, last year, the guidelines, the European guidelines, were adapted as of March the 1st, 2024, pertaining to sufficiency in AI-related inventions. So the guidelines were updated to say, occasionally applications are filed in which there is a fundamental insufficiency in the invention in the sense that it cannot be carried out by a person skilled in the art. Another example can be found in the field of artificial intelligence, if the mathematical methods and the training data sets are disclosed in insufficient detail to reproduce the technical effect over the whole range claimed. Such a lack of detail may result in a disclosure that is more like an invitation to a research program. So this clearly indicates that there is going to be some requirement for some training data sets or some kind of data that will allow the technical effect of your invention, that is an AI invention, to be established. The guidelines go on further to say the technical effect that a machine learning algorithm achieves may be readily apparent or established by explanations, mathematical proof, experimental data, or the like. While mere allegations are not enough, comprehensive proof is not required either. If the technical effect is dependent on particular characteristics of the training data set used, those characteristics that are required to reproduce the technical effect must be disclosed, unless the skilled person can determine them without undue burden using common general knowledge. However, in general, there is no need to disclose the specific training data set itself. So there's a little bit of a contradiction here about saying that you need to sufficiently disclose your AI, but you don't necessarily need to provide an entire training data set. You need to focus on the particular characteristics that give the invention its inventiveness. Okay, so how to avoid sufficiency objections, specifically in AI applications. It's important to describe the AI in sufficient detail that a person skilled in the art can reproduce it. This is even more important if the AI is providing some or all of the inventive step. And it can be helpful to include examples of training data sets, but it does, of course, depend a little bit on a case-by-case basis. Okay, so moving on to clarity. And Article 84 specifies that the claims shall define the matter for which protection is sought. They shall be clear and concise and be supported by the description. The EPO guidelines say about clarity that the claims must be supported by the description. This means that there must be a basis in the description for the subject matter of every claim, and that the scope of the claims must not be broader than is justified by the extent of the description and drawings, and also the contribution to the art. So this will come up a little bit later. One of the pending referrals is about description amendments, which is another thing that is slightly different to US prosecution, where the examiners often ask the description to be amended in order for the description to be brought in line with the claims. There's a bit of conflict between examiners wanting descriptions to be amended and applicants and attorneys fighting against that a bit. We're hoping for some more clarity, ironically, on that coming up. But for now, generally, we are required to amend the description at least a little bit, or usually on grant or just before. So another quick inventive step refresh with a bit of a computer implemented AI invention flavor. So we talked about the problem solution approach before, and the examiners basically have a tick box that they have to fill in order to say that something is inventive, and they follow this approach. The three main stages being determining the closest prior art, establishing the objective technical problem from your differences between your claim and the closest prior art, and then considering whether those differences would have been obvious to the skilled person. So when we're looking at computer implemented inventions and inventive step, this is somewhat akin to the 101 objections that we see from the US. It's just brought up in a slightly different way in Europe. So the way this plays out is that once you've identified the differences from the prior art or the closest prior art document, it's then identified whether those differences are technical. And if the examiner considers that those differences are non-technical, the way that they are treated is that all of those differences that are non-technical can be given straight to the skilled person, and then they form part of the objective technical problem. This then makes it very easy for the skilled person to arrive at the solution because they are directly provided with those novel features. So only technical features can be considered in Europe in inventive step, and inventive step can only be supported by technical features which serve a technical purpose. So ways to avoid some of these objections in Europe, you need to show that the invention involves a technical solution to a technical problem. This description should preferably include specific technical purpose for the invention, or describe how it makes a computer work better if it's a computer implemented invention. In both cases, it's useful to have a lot of technical applications and implementations. To be patentable, a claim should include technical elements, hardware examples such as you see in the US as well, but simply including a standard computer is unlikely to be enough to overcome these kinds of objections. When you're instructing your EP attorneys, it's helpful if you provide detail about what the invention is achieving and how it does this based on those distinguishing features that we talked about, according to the problem solution approach. So I have listed some technical contributions here. I'm not going to go through them all individually, but the slides are going to be passed around so you can peruse at your leisure or as you come up with a case that is having some difficulties in this area. But generally speaking, if you have a technical application, and by that I mean something that is affected outside the computer, you're likely to be okay. If you're doing something that's in cryptographic, for example, that's generally considered technical enough. Image processing, all that kind of thing is usually gets over that technical hurdle. So I've also included some fintech examples because they're, in addition to the computer implemented invention being a problem, we often also see business methods being if you non-technical or considered non-patentable. I would say that it can be very helpful to be explicit in what your technical problem is if you're writing or drafting your patent application. Don't be shy about saying if, for example, your invention is about fraud. Don't be afraid to say that. And here is some examples for you to come back to at a later date about possible technical problems and solutions that you can use in your arguments in getting over the inventive step hurdle for some of these more difficult computer implemented inventions. So on a slight tangent, this isn't related to European prosecution, but if you do work in AI and you prosecute AI applications, it might be of interest to you, and you may already be aware of the emotional perception case, which has been going through the courts in the UK. It's interesting because it might or might not make the UK a possible better place to prosecute your AI applications, because Europe is quite strict and can be difficult, but it largely remains to be seen about those kinds of decisions, but that's something that's coming up soon. So the UK EPO is quite famous for having an even harder stance on computer implemented inventions than the European Patent Office. But there was an initial decision issued by the High Court that ruled that an invention involving an ANN should not be objected to on the grounds of patentability under this program for a computer exclusion. So there was a very brief period where the UK looked like a great place for filing your AI applications because of this. The Court of Appeal then fairly quickly overturned this High Court decision and reverted the treatment of AI applications back to what it had been before, as being treated as a program for a computer, and that is where we are currently. There was a flurry of filings for AI applicants in that brief window, and now they're being treated like the same way that they would have been before, and it's quite difficult in the UK. But the Supreme Court will rule on whether an ANN should be considered a computer program, and this hearing is anticipated to be mid this year. We might get a judgment by the end of the year, but just something to look out for if you do have a lot of AI applicants. So moving now on to some of the G decisions. These are the ones that are about ask questions of law to the enlarged boards of appeal, and we get some kind of interpretation and application of the EPC as a result. So the first one is looking at plausibility. So the case related to an insecticide, which was made up of a specific combination of compounds. The technical effect relied on by the applicant was the synergistic effect provided by a combination of compounds, and some post-published data was given in support of this technical effect. The opposition was rejected based on this only being demonstrated with the use of post-published data. This rejection of the opposition was appealed, and questions were referred to the enlarged board, seeking an answer to the admissibility of whether this post-published evidence is allowable, particularly in relation to proving a technical effect. So the result was that post-published data can be used to support technical effect, with the conditions that it is encompassed within the teachings and disclosure provided by the originally disclosed invention. So there have been some cases which have applied this G decision in the life sciences particularly. So the first case, T873 of 21, related to a technical effect of improvements of metabolic disorder in equines. The technical effect was acknowledged in this case with post-published data in view of known effects of claimed agents individually, and also mention of the improved sensitivity, which was in the application as filed. T1551 of 22 related to a technical effect of improved foaming properties for cosmetic preparation. and post-published data was taken into consideration as a technical effect encompassed by technical teaching and embodied by the original application. And finally, T1551 of 22, post-published data was used to support the technical effect of improved photostability in a drug, which was used to treat pulmonary arterial hypertension. So that's life sciences, but again, there's a bit of a software flavor. So although plausibility is, again, classically more seen in life sciences, there was a recent decision, T687 of 22, where the central issue was about, it was a software invention, and the question of whether it provided a credible technical effect that solved an objective technical problem. So the patentee attempted to identify a technical problem, such as improved energy efficiency, circuit stability, etc. But the Board of Appeal said that they could not identify any technical effects that could be credibly associated with the distinguishing features. The interesting part of the write-up of the case was that even though the patentee did not in this case provide any post-published data, the board actually cited the decision saying that, and specifically reason 25 of the G decision, which says that the technical problem must be derived from effects directly and causally related to the technical features of the claimed invention. An effect could not be validly used in the formulation of the technical problem if the effect required additional information not at the disposal of the skilled person, even after taking into account the content of the application in question. So we basically see that this is relevant in software inventions, and it comes back a little bit to what I was saying before about sufficiency, particularly in AI-related inventions. And this is just a copy of that extract from the guidelines that I discussed earlier. So part of the problem in AI applications is that they can often be filed quite early, and supporting evidence might not be available at the time of the filing. But this case is useful in saying that post-published data could be used to support a supposed technical effect. But the application should still state this technical advantage. But data used in training and testing and so on could be used or introduced after filing. So moving on now to another decision, which is dealing with entitlement to priority. So the head note of the decision was that the European Patent Office is competent to assess whether a party is entitled to claim priority, and there is a rebuttable presumption that the applicant claiming priority is entitled to claim priority. So the rebuttable presumption also applies in situations where the European patent application derives from a PCT application, where the priority applicant or applicants are not identical with the subsequent applicant or applicants. For example, in a situation where a PCT application was jointly filed by parties A and B, for example, designating party A for one or more designated states, such as we used to see the inventors being party A for US filed applications, and party B being, for example, the applicant for one or more other designated states, so Europe or other rest of the world states. So claiming priority from an earlier patent application designating party A, i.e. the inventors, as the applicant, and the joint filing implies an agreement between the parties A and B, which allows party B to rely on this priority unless there are substantial factual indications to the contrary. So this is interesting because it reverses some previous case law, and it assumes that the priority claim is valid and places the burden of proving the validity of this priority claim back onto the challenger, which is much more challenging for the challenger to prove. So the challenger has to demonstrate that specific facts raise serious doubts as to the applicant's entitlement to priority. So the enlarged Board of Appeal took the general position that the EPC should not establish higher formal requirements than those established under national laws that may be relevant in the context of a European application. To the contrary, the EPO should adapt itself to the lowest standards established under national laws and accept informal or tacit transfers of priority rights under almost any circumstances. Now, whilst this may be true, I would always advise that your priority is correct and suitable assignments are in place before filing a PCT or a direct EP, as priority cannot be retrospectively assigned. So moving on very quickly to reduction fees for SMEs. I don't know if you have many SME applicants that this will be helpful for, but we didn't have this before. So micro entities will now benefit from a 30% reduction in all main fees throughout patent grant procedure under specific rules of them having filed fewer than 5 applications in the last 5 years. They are available to a natural person, an individual, a micro enterprise, or a non-profit organization, a university, etc. And a micro enterprise has been defined as an enterprise which employs fewer than 10 full-time persons and an annual turnover and/or annual balance sheet total of up to 2 million euros. There is a bit more information about that to follow if you want to when you get the slides, just so you know that that is now available. Okay, so finally, moving on to pending referrals and what is coming up in the next year or so at the European Patent Office. So there is going to be a decision about prior disclosures. The questions that have been raised are about whether a product that is being put on the market before the filing date, but which internal structure could not be analyzed or reproduced without any due burden, whether that still construes a prior disclosure. The second one, which will be greatly anticipated and watched in Europe, will be about interpreting the claims. And this is what I mentioned earlier about amendments to the description and how much the description should conform to the claims and how much description and figures should be consulted when interpreting the claims to assess patentability. So yes, that's greatly hotly anticipated over here. Whether you're interested, I don't know, but we are very much here in Europe. And the final pending referral that might be of interest is about after an appeal has been withdrawn, if a third party has intervened during the proceedings, whether it can be continued with them and whether they can acquire an appellant status in this instance. So that is it from me. Thank you very much for listening. And now I will take your questions.
So Claire, thanks so much for a really fantastic presentation. I realise you've covered a lot of ground in in quite a short time. We have one question actually about going back to the start of the presentation about claims, and it's to do with the payment of fees claims. And someone has asked, do they express an opinion on every claim, even if you pay the claims for all the fees, or do they limit opinions? I think this is referring to where you have an opinion from the examiner together with the search report.
Sorry.
So do the examiners express an opinion on all of the claims, or just I guess it's
Okay.
just any
Yeah.
claim?
So the examiners will, if they decide that the claims involve more than one invention, they will focus their search and examination on the first invention that they identify. If you have paid for all of your claims to be looked at, they will be, but if they won't be if the examiner considers that if there's a unity objection, and then they will just restrict it to the first invention. Does that make sense?
Yes, thank you very much.
But they won't look at any claims that you haven't paid for.
Yeah. And I have a question about the application of the recent decision on the entitlement priority. So I realize that there is a real softening of, or in theory, there's a real softening of the rules.
Yeah.
I do like your suggestion that actually these issues, priority issues and entitlement, are sorted before you file a PCT application. But I'm wondering whether, because sometimes legal changes take a while to come through the system, are you actually seeing changes on the ground in terms of what examiners are doing? Are they really putting that into practice?
Honestly, this hasn't come up for me in that most of my clients are European based anyway, so it's not an issue, because I think the issue tends to be more from US originating, where the inventors are the original applicants. That's not very helpful, I realize.
No, I understand, and sometimes it takes a while for changes like that to filter through. But I do like the fact that you're advising caution, because you kind of never know where these things actually end up.
Yeah, it's always good practice to make sure you've got those things. Well, on filing actually is very helpful, because sometimes inventors leave, don't they? And then it gets even more complicated.
Yeah, yeah. And another question is to do with you've mentioned a couple of times that parts of European practice which perhaps were relevant, say, in biotech or in chemistry, are starting to feed more into the electronics and software with the advent of artificial intelligence. Is that starting to really crop up more? Or because when I was practicing, it would have been quite unusual in a software application to have a sufficiency argument, objection, for
Yeah.
example, or this concept of also plausibility.
Yeah.
So on the ground, what are you seeing happening?
I think what we're seeing is that it's difficult. Basically, like, they are being treated quite harshly by the EPO. Again, a lot of this is still, like you said, with the entitlement priority. It's still taking a while to work its way through the system, and I can't think directly of any sufficiency or plausibility objections that have been raised. I think a lot of it is speculative at the moment and being prepared for these kind of things to come up.
I see, so it's more of in anticipation of these problems.
Yeah,
Yeah.
as much as it is possible to anticipate.
Yeah.
Yeah.
I have another couple of questions. Is there any difference between micro-entity versus micro-enterprise?
Let me, I think there's a link that I shared. I'm not sure what did it, well, I think generally speaking, a microentity is described as one of these three listed here, and a microenterprise is a specific version of a microentity. Does that solve your question?
Yep, I think so. We also have a question on what are the translation requirements for unitary patents? Assuming a unitary patent, the original application was filed in English.
Yeah, so there are what we see most people doing, you have to file your application into one other EU language. So your claims will already have been translated into French and German. We often, or very often, see, because Spain is not part of, it's not part of the unitary patent, but it is still an EU language, and applicants that want to validate that they want a unitary patent and they want protection in Spain, they will very often choose Spain for their translated language, because you have to translate the entire application anyway in Spain. So there is a translational requirement that, and luckily Ireland is part of the EU still, so English is an allowed language, but it does have to be translated into a second language as well.
Thank you very much for that. And a final question that I'm sure you could talk on this for hours, but just quickly, how are UPC decisions diverging from EPO practice in the assessment of inventive step?
Do you know, it's not something I've actually looked at. I don't think I could give a good answer to that. I don't know.
I guess
Yeah.
it might be a bit early to really say, actually. If the court's been active now for two years.
Yeah.
I guess time may tell.
Yeah, we're just getting through, the first real substantive decisions. So, well, interestingly, the first, a lot of the first filed requests at the European under the new court were filed in Germany. So if you go back far enough, it looked like they were all being filed in German. But then there was a decision about you could file it in English, and now they're predominantly filed in English. So I think you're right that it's a bit too early to see, and it could change. Keep an eye on.
Well, I'm afraid we're out of time now. Thank you so much, Claire, for a really interesting presentation. It's been absolutely fantastic. And thank you to everyone for joining the webinar this evening. The SLW Institute will be back with additional webinars in the next couple of months. We will be continuing our international series. And so thank you very much for joining us this evening. And many thanks again to Claire for a really wonderful presentation. Thank you so much.
Thank you.